Hello, hi everyone, and welcome to the Armenian Institute. My name is Narine Evlasyan, and I am AI's program manager. I'm happy to welcome you to this panel discussion, Treading on Borders, Treading on Justice, Aggression Against Armenia and Artsakh, and Human Rights Violations. Now, this panel was originally motivated by the events that happened on the 13th, 14th September, with some appalling war crimes that took place, were committed by Azerbaijani troops on Armenian soil and within internationally recognized Armenian borders. But what kind of makes it even more important is that right now, as you know, Artsakh for several days already has been in a blockade, cut off from Armenia and the rest of the world. And that also includes cutting off gas supplies and basically bringing it to the brink of a humanitarian disaster. So I think it's actually really important that this panel is happening today, right now. Maybe it's really appropriate moment for it to happen. Now, before I start introducing our moderator, let me just very briefly go through some housekeeping. So this event is being recorded. If you don't want to be seen in the recording, you can switch off your cameras. Please mute yourselves unless you are the speaker at a particular time. If you have questions, you can leave those in the chat. Hopefully, towards the end of the event, we'll have some time and we'll go through some of those. And I believe we can actually start. So I'm happy to introduce our moderator, Dr. Artem Donoyan. So he is a sociologist and visiting professor of global studies at Hamline University in St. Paul, Minnesota. His research interests include sociology of religion, religion and politics in the South Caucasus, and religion and nationalism in post-Soviet Russia. So his articles have appeared in Demokratizatsiya, the Journal of Post-Soviet Democratization Society, and Modern Greek Studies Yearbook, among others. He has been a frequent guest on the BBC, Deutsche Welle, France 24, and other outlets. He's the editor of the recently published volume Black Garden Aflame, the Nagorno-Karabakh conflict, and the Soviet and Russian press. So, Artyom, would you like to start with the panel and introducing our speakers?
Thank you, Narine, and thank you to the Armenian Institute for organizing this event, and thank you for thinking of me in becoming a moderator for this distinguished speakers. To say that we're living in some desperate times, I think is an understatement. Desperate, not just for the Armenians, but any number of small nations that find ourselves in the midst of warring and clashing geopolitical interests, within which the small nations or even larger ones have been deprived of agency in claiming their future. So it is utterly important that an event of this sort is put together. The events that are happening in Nagorno-Karabakh, the events that are happening in the greater South Caucasus are defining moments right now. And so to have a distinguished coterie of speakers to pick their minds on these issues and related issues is, I think, extremely important, not just for me professionally as a researcher who looks into this conflict professionally, but also for the wider Armenian community and those non-Armenians that are interested in the area and are interested in the conflict and are drawn for one reason or another to the region. Some are drawn, as we know, for exotic reasons. Some are drawn for reasons of their profession, and some are drawn because how can you not like the South Caucasus with the tapestry of cultures that meet there and and produce such wonderful architectural gems and literature and so on and so forth. Be that as it may, I hope, my hope is that the conversations that we're going to have today will contribute constructively to our understanding of the regional dynamics, but most importantly, from the vantage point of human rights and human rights violations, because we're all concerned about human rights when there is a human rights violation. And I think the list of the participants and the speakers speaks to that fact, that we take these issues seriously, and we are going for the A-listers here, where we want some of the best and the brightest of the minds that toil in the field to bring us their wisdom, to bring us their vision, to bring us their understanding, so that we understand and have a better picture and a larger picture of what is happening and what our next contribution should be and what they should look like. Without further ado, some ground rules of my own. We have decided that we're going to have the speakers going in a particular order so that we can have a much more fruitful conversation. Our first speaker today is the Honorable Gasya Abgaryan, judge of the Superior Court of California, appointed by the Governor Brown in 2014. She's a trial judge presiding over felony cases in Orange County, California. She was born in Aleppo, Syria during the Six-Day War between Israel and Syria in 1967 and grew up in the civil war in Beirut, Lebanon. She holds a BA in political science from University of California, Irvine. She received her JD from the University of Laverne College of Law, also in California. She worked as a deputy public defender for 8 years. In 2008, she started her own law firm, Abgaryan Defense APC. Days after the ceasefire of the 44-day war in Artsakh, she helped establish the Center for Truth and Justice, an important institution that is elucidating some of the most heinous war crimes that Azerbaijan's army is committing. And she is also teaching young law students and lawyers in Armenia and Artsakh how to collect testimonial evidence on war crimes, an especially important thing because Armenian law is lacking in evidential gathering aspects. So Judge Abgaryan was awarded the 2022 Alba Witkin Humanitarian Award by both California judges and the Witkin Foundations. Without further ado, Your Honor, the floor is yours.
Thank you. Thank you to the Armenian Institute. Thank you, Artyom, and to my esteemed colleagues who are here. And we are definitely covering the globe. We're on a 12-hour time difference between Yerevan and California. And then there's London in the middle for facilitating this. So I just want to say thank you for bringing this group together. So there's a few things that I'd like to just bring to light. The Center for Truth and Justice sits in a unique position that did not exist before the 44-day war. Had we had foresight as a nation, I wish we had established it 30 years ago. And the reason it came to be is because it was a reaction to starting with the late 1800 genocide, and then obviously the 1915 genocide committed. How good has the nation of Armenia been in collecting its war crime evidence over the decades? There's a lot that has been gathered, but nothing that has been courtroom worthy. It's always been, my grandmother's story, my uncle's story, I've heard, or I have this heirloom left behind from 100 years ago. And there's a huge difference between storytelling and testimonial evidence that is courtroom worthy. So the purpose of the Center for Truth and Justice was, how do we help the nation of Armenia and the sovereignty of Armenia, as well as Artsakh, in bringing forth these war crimes in a fashion that will be admissible in court. And just like Artyom, you said, the tradition of collecting forensic evidence and testimonial evidence in Armenia, the tradition simply does not exist, because just like all other post-Soviet republics, its traditions have been inherited from the Soviet era, where testimonial evidence is simply not used in the format that has been accepted internationally. And the reason our group makes sense is because those international standards of making testimonial evidence admissible in court were actually implemented in the 40s by the US federal courts. So it's based on US Code of Evidence. That's where the ICJ and other courts take their evidence code. So we decided to do two things simultaneously, because 10, 20, 30 years from now, the Center for Truth and Justice hopefully will not be necessary, because these skills will be transferred over to Armenia, or the Center for Truth and Justice will exist in Armenia entirely, where the lawyers and law students and investigators will take on the responsibility of collecting testimonial evidence in the fashion and the format that is admissible in international courts. So we took on the responsibility of, one, let's teach students and lawyers in Armenia how to do this. So we give them that agency, the ability to take on the responsibility and the mechanism of how to do this correctly. But in the meantime, we also know, as Yerish is going to be telling you, and so is Sheila, simultaneous to teaching, these war crimes needed to be documented in the fashion that I described, because actively Armenia has brought cases to court, whether it's in European court or in the International Court of Justice, which I don't need to talk about because there are other experts here who will discuss those with you. So we've gathered over, almost 400 testimonial evidence. And what I'd love to say is, my favorite part of it is, we've done the same work in Artsakh parallel to Armenia. Okay, so we have a team of law students and lawyers, both in Artsakh and in Armenia, that have taken on the responsibility because we teach these seminars. It's a law clinic. It's the only hands-on program where they actually go do this work day in and day out, and then they have quality control, because these law students and lawyers in Artsakh and Armenia, every two students in Armenia or Artsakh has a team leader in the United States who's a licensed lawyer that does quality control by reviewing their work and telling them how to correct it, how to fix it. This is really difficult work, and I will explain it to you this way. The Center for Truth and Justice is a human rights organization that is based in the US. We are not an Armenian organization. We're an American organization. We just happen to have a lot of Armenians involved in the work we do, because right now we're focused on Artsakh and Armenia. We have also done similar work in northern Syria, and we've been invited to do similar work in Somalia. Why do I bring this to light? Is because we as an Armenian nation need to produce work at that international level, not the Armenian standard, but the international standard, okay? In order for us to be taken seriously and create agency. The purpose of Center for Truth and Justice is to say, no, the UN is not going to come gather evidence. Macron is not going to come to save us. The US is not going to take our cases to court. We have to stop being a victim nation, and we have to have our own agency. In our case, because we're a bunch of lawyers and a judge, the agency that we've created is the legal agency. But what I want to do is take a minute and talk about how there is no such thing as anything pure, whether it's legal or otherwise. Everything is political. All right. And why do I say that is because if you gather the truth and you gather the evidence and you hold the truth, you don't just wait to take it to court. You use it in a political environment, for example, with members of Congress. We've been pushing the evidence to members of Congress on a regular basis. 2 days ago, there was a South Caucasus hearing in Congress here, US House, where the Lachin corridor had been shut down for barely 24 hours. We pushed evidence and information to members of the committee, the subcommittee that had a hearing. And they were actually able, and the hearing was the undersecretary from State Department, Blinken's undersecretary, had to face the subcommittee on the House side and answer questions. And lo and behold, within 24 hours, members of Congress were asking her questions about the shutting of the Lachin corridor. And that's what evidence does. You don't just collect it in order for it to become history, in order for us to have a legacy, which are crucial, absolutely crucial. You also use it in the political arena. This is Ukraine has come up with this terminology, which is not warfare, but legal fare or something like that, where the fighting takes place in courtrooms. That's 100% true, but everything legal is also political. And it's also educational. So we use our educational tools, our testimonial tools to get them to the right places at the right time. Now, did it make a difference? Well, 24 hours after the congressional hearings, State Department did make a statement with regards to opening of the Lachin corridor. Did they make them open it? No, that's a political issue. That's a geopolitical issue, and that's a much more complicated issue. I don't think we're here to discuss all of those. That's a different panel for a different day. The other thing I want to say is we are here to complement the work that is done by Yeri Shegiragosian's department. We're here to complement that the work that is being done by the Human Rights Defender's Office, both in Artsakh and in Armenia. And the reason we sit in a unique position is, as I said, we're an American organization, and we use a methodology that is internationally accepted, and it's on our website in collecting our testimonies. So when we put out these testimonies, no one can accuse us of being subjective, but rather credible and trustworthy. And that's the role we can play, which is different than the role that the Armenian side can play, because we are this American organization on the outside collecting independent information and not at the behest of the government. So it takes these two parts that come together to describe the truth, and our evidence is being produced and provided in reports, as well as offered to all law firms and organizations that are there to defend human rights, whether it's at the ICJ or otherwise. Our information is available as long as you pass muster with us and you're not going to use it for alternative partisan reasons. So with that, I'd like to keep it short, and I'm open to questions, and thank you for having me.
Thank you, Judge Apkarian, for your insightful comments and for the brief excursus into the history of the ICGA. And I'm sure some of our listeners, some of our viewers, and I myself have a couple of questions we'll revisit after everyone has spoken. I hope you'll be able to stay beyond so I can ask that question too. Our next speaker needs no introduction, but I will do the introduction just because the occasion calls for it. Sheila Paylan before I say anything else, is a brilliant legal mind and somebody who needs to pay attention. I know I read everything she writes when they are published, because my legal education has been through podcasts and Netflix documentaries. So, so Sheila Paylan is an international criminal lawyer, war crimes investigator, human rights and gender expert, and former legal advisor to the United Nations. She spent more than 15 years advising the judges and senior officials of various UN-backed international criminal tribunals, including for Rwanda, the former Yugoslavia, and the Khmer Rouge in Cambodia. From 2019 to 2021, she was appointed by the UN Office of High Commissioner for Human Rights as the legal advisor and sexual and gender-based violence specialist to a team of international experts mandated to assist the judicial and military authorities of the Democratic Republic of Congo, or DRC, with investigating and prosecuting war crimes, crimes against humanity, and gross human rights violations. I think your work is of utmost importance, Sheila, and just I wanted to thank you personally for your work, and floor is yours.
Thank you, Artyom. Thank you to the Armenian Institute, and I can't believe how many people are here. I don't think I've been on a panel where there have been so many participants, like, ever. Online, I mean, you know. So following in Judge Abkarian's footsteps, I'm going to talk. I've decided to focus on mainly the responsibility to protect, because I think we all have like overlapping issues, but this is one that I kind of fell into mainly just right after the 2020 war. And so I'm going to talk about why we need an international investigative and accountability mechanism and other transitional justice mechanisms, and what certain measures under this doctrine of R2P, or the responsibility to protect, can look like. So first, I'll just quickly explain what it is. It's a relatively new norm. It's not a legal norm, but it's a sort of soft law political norm that seeks to ensure, that was created basically in 2005 in the aftermath of the Rwandan and former Yugoslavia situations. So it's meant to ensure that the international community never again fails to halt or stop mass atrocity crimes from being committed. There are four: the genocide, crimes against humanity, war crimes, and ethnic cleansing. It was unanimously adopted, like the whole entire world got together. It was the largest gathering of head of states and governments in history in 2005, and they all agreed that they were going to adopt this new principle of responsibility to protect. And it has three pillars. The first one is, I mean, pretty straightforward. Every state has the responsibility to protect their own citizens from atrocity crimes. Obviously, like, don't kill your own people. The second one is that the wider international community has the responsibility to help or to encourage and assist individual states in meeting their responsibility, not to, like, their responsibility to protect their own populations. So let's say there are, you know, rebel groups within a country that are terrorizing the population, and the state can't do anything to protect, or can't do much, then other countries are supposed to come in and help them. And the third, if all else fails, so if a state is manifestly failing to protect its populations, or worse, like perpetrating them, then the international community has made this commitment that it is prepared to take appropriate, collective, timely, and decisive action. It's become, over the last 20 years, almost a like quasi-legal norm, because it's been invoked so many times in UN Security Council resolutions and Human Rights Council resolutions. And it's also been used, I mean, a couple of times, like the intervention into Libya was based on this principle of responsibility to protect, but was kind of considered to be a bit of a failure. So you have less and less political will to invoke R2P. But it's still like the theory of it is so important and so valuable, which is why we have to keep talking about it, because the idea is really good. So how is this relevant to Armenia and Artsakh? With respect to war crimes or crimes against humanity or what have you, atrocity crimes perpetrated against Armenian citizens, let's say like after Azerbaijan's invasion of Armenia, there are many tools that are already available to Armenia that it can and should use, and I'm not going to touch on them. I'm going to let my co-colleagues, especially Yarisha, will discuss what is available to Armenia. States are required to investigate and prosecute international crimes committed by their own citizens, as well as those of foreign nationals who might be in their custody. So there's an emerging and increasingly also more like there's this robust concept of universal jurisdiction that's also gaining ground, where states that recognize it can also even investigate and potentially prosecute foreign nationals who are not even on their territory. But with respect to the Armenians of Artsakh, the options are much more limited because they're part of an unrecognized state. And so they're incapable of participating like in the international spheres that would permit them to access and use these tools. They are, and you know, I'm sorry to say it, but they are for all intents and purposes considered to form, I mean, at the international level, they're considered to form part of the population of Artsakh, of Azerbaijan. This population does wish to secede and separate from Azerbaijan, and with obviously very good reason. But because they're considered to form part of Azerbaijan, the R2P system can only be implemented in this sort of linear chronological type form, where you start from 1, you go to 2, and then you go to the 3rd pillar. Azerbaijan's actions make it clear that pillars 1 and 2 just don't apply. Like 1, because obviously Azerbaijan is a perpetrator, can't protect its own population because they're committing the crimes. And 2, because in order to be able to encourage and assist a country in being able to protect its own population, that country needs to want to be able to do it. And a very bright person brought that to my attention recently. So that makes sense. So you can't have 1 and 2. You're left with pillar 3, and that stipulates that if a country is unable to protect its citizens, then the international community must act swiftly to fill in this protection void. So the measures that apply, they're like really the sky's the limit, but it's case specific, and you would have to start with the least invasive or aggressive options and then scale up as needed. So non-military tools would involve like mediation, monitoring, observer missions, fact-finding missions, commissions of inquiry, public advocacy, like diplomatic means. Some of this is already happening, but clearly not enough of it. And then the more robust tools would be acting under Chapter 7 of the UN Charter, where the international community could impose sanctions or establish a peacekeeping mission, authorize military action, all with the express purpose, of course, of protecting civilians. And the Russians are sort of doing some of this already for now. But what we know is that it's also not enough. And either like the world needs to ramp up its response, or, I made this argument recently in a Newsweek article that they become complicit at this stage in what looks like is going to be the next Armenian genocide or ethnic cleansing. Like I said, every situation is different, so it calls for case-specific action. And I have argued that in the case of Nagorno-Karabakh or Artsakh, I still call it Nagorno-Karabakh all the time, like it just rolls off my tongue. I've argued that remedial secession is an appropriate R2P measure under Pillar 3. And I cannot tell you how many of my former professors think I'm nuts, but I really stand by it, because like, why should it be limited to just sanctions? It's or, you know, peacekeeping mission. It's extremely relevant in this situation and will be absolutely effective, as it was for Kosovo, to definitively resolve this, you know, perpetration of mass atrocity crimes. Especially where the people who are vying for self-determination become the target of those crimes for that reason. And the lack of recognition is an impediment to states actually being able to enter, as we see now with the blockade, to do anything about it. So in this way, I really think that we might be at a stage to be able to come back and push the remedial secession factor forward again, because it functions really analogously to R2P, where sovereignty and territorial integrity are not assured when a state abuses the right of its inhabitants. So I still stand by this argument, perhaps even more so now. It's a long shot, but whatever the case may be, you know, the number and the quality of measures that are being implemented by the international community that has a responsibility to act is too little, too few, too far in between. And yeah, so I can't see any other way other than the tools that Armenia is using for Armenia. Could use some for Artsakh. I'll let my co-speakers talk about that. But there's a responsibility also at the international level that we need to be sort of, you know, pointing our finger at and calling people out for not acting, failing to act. That's all I have to say about that.
Thank you, Sheila, for your insightful comments and clearing up some of the confusion that exists in our understanding about R2P and remedial secession. And I hope we'll have some questions for you at the end of the entire conversation here. Our next speaker is Anna Karapetyan, who is the head of the International Cooperation Department of the Office of the Human Rights Defender of Armenia. She has previously worked at the Ministry of Justice of the Republic of Armenia. She has significant experience of elaborating and implementing policies regarding the protection of human rights, as well as planning and organizing international cooperation of public institutions with foreign state bodies and international organizations. Currently, among other things, she's responsible for elaborating and presenting the human rights defenders' communications, as well as the applications to the relevant United Nations monitoring bodies regarding the violations of the rights of the civilians by Azerbaijani armed forces, I'm assuming both in Armenia and in Artsakh, in Nagorno-Karabakh, the rights of missing persons, prisoners of war, and much more. Ms. Karapetyan, the floor is yours.
Mr. Tonoyan, thank you very much for having me here, and thank you for distinguished colleagues for their insightful comments. So first of all, starting my speech, I would like to speak about the reports that are being produced by the Human Rights Defender Office. As you know, we are the institution who have an A status, which means that we are entailed to provide information and to provide reports to international organizations such as UN monitoring bodies and applications to international other monitoring mechanisms, and to use it for the protection of civilians and civilians in Artsakh and Armenia as well. So as you know today, or I don't know whether you have seen already, the Human Rights Defender Office in cooperation with Artsakh Ombudsman, we have published a report. The data of this report reflects only the facts of December 12 to 2014, and this means that we have covered all the situation on the blockade of the Lachin corridor by the Azerbaijani groups, and the report provides thorough information, a credible and trustworthy information, because as a national human rights institution, we have to be credible, we have to be trustworthy, we have to collect information through different sources, and we have done it and we continue by doing so. And you know, this is not the first attempt of Azerbaijan to block the Lachin corridor, and it has been the second time. And so in December, on December 3, a group of Azerbaijani posing as environmental activists had blocked the Lachin corridor again. And it has been a continuous action by the Azerbaijani authorities. And we have revealed also the artificial nature of the environmental activism and links to the Azerbaijani government. In our report, we see that environmental protests are orchestrated by the Azerbaijani authorities, and it is being also revealed by just going through the Facebook public pages of these activists, and you see that these people did not conceal their direct ties with Azerbaijani government, and they praise the hatred against the Armenians. And we have seen also on their Facebook social pages the infiltration related to information, as well as special servicemen were engaged in this activism of environmentalists. The majority of the participants of the protests are representatives of non-governmental organizations who are exclusively financed by the Azerbaijani state. And humanitarian crises create complex and persistent issue related to the realization of the human rights to health and healthcare. And in this regard, now the Azerbaijani act of blocking the Lachin corridor has created various complications in relation to the right of civilian population of Artsakh. The transfer of patients in critical condition for urgent treatment and hospitalization in the Republican medical centers of Armenia has become impossible. And in that sense, the report also gathered information about the rights of the child who are deprived of their rights to security, right to education, rights to life with a family. And we know that more than 270 children were blocked and are now in Sunik and in Goris mainly, and in Yerevan. And about 70 of them are without their parents because they were attending the Junior Eurovision Song Contest. And so it is important for us to ensure the right of these children to go back to their homes. So what has already been said is that the Human Rights Defender Office provides these reports to all relevant international actors, and we call upon the government, international regional organizations with a mandate to protect human rights and others involved in the resolution of the conflict to take all measures to stop this humanitarian crisis in Artsakh. We provide this report to relevant UN mechanism, to the Council of Europe, to the heads of the relevant commissions in different countries. We have also shared the report with the relevant national human rights institution networks, and we have received, we didn't receive relevant positive feedback from them as of now, but we see that our report is being used widely by different actors and international actors in their reports. And so it's important for us to continue gathering information and to provide credible and trustworthy information. And as Mrs. Abkaryan already mentioned, it's important to gather information because evidence is more than important for us and all of us, and it should be used in international tribunals. And for these purposes, we work very closely with the Ombudsman of Artsakh. As you know, he didn't have any opportunities to apply to international courts and international mechanism, and that's why we are here to also voice to be the voice also of the Ombudsman of Artsakh. And for the other part of our speech from the Human Rights Defender Office, I will ask my colleague Havine to complement my speech by also mentioning the Armenophobic rhetoric of Azerbaijan, which is being continued for about decades. You have already seen the reports of the Ombudsman Office that provided information about the continuous Armenophobic rhetoric, which is being which is being also done nowadays by the high-level public officials of Azerbaijan. So, Herine, please take the floor.
Thank you.
Oh, I would like.
Present myself or
Yeah, I will. Well, thank you, Anna, for your comments and clarifications regarding the issue of the work of the human rights defender and your attempt to represent the population of Artsakh as their rights are being violated and remain unaddressed. Our next speaker is Herine Yengoyan, who is the assistant to the human rights defender of Armenia. Throughout her career, she has worked on devising policies and legislation aimed at combating discrimination and hate speech, and was also involved in the finalization of the new criminal code of the Republic of Armenia, among other things, being also responsible for revising provision on crimes against humanity and hate speech. Presently, Herine continues to be mainly engaged in activities related to the fight against discrimination, hate speech, and hate crime, implementing the activities of the Office of the Human Rights Defender in these relevant fields. She is also responsible for analyzing the Armenophobic policy of Azerbaijan and outlining the main developments, trends, and patterns regarding Armenophobia in the Azerbaijani Republic. As a lifelong almost reader of Azerbaijani press myself, of late, the Armenophobia has gone through the roof, as the saying goes in the United States. So I'm especially interested, just professionally, to hear about your findings and see you talk about them. The floor is yours, Herine, and I hope the connection works better this time. Maybe you can stop the video. Maybe that would allow a better bandwidth for you to, because it keeps cutting off.
okay, I will try to speak without the video, and we'll see if that works. I'm sorry. So as my colleague Anna already mentioned, I will speak more about the work that the Office of the Human Rights Defender is doing regarding the monitoring gender policy. I should first mention that we constantly and continuously monitor Azerbaijani media. This usually mainly includes online mass media, covering also the official statements, interviews, and so on. But additionally, more like on an ad hoc basis, we also monitor social media. This includes Telegram, Twitter, Facebook, YouTube. We don't do this constantly, but we do this from time to time when needed, because obviously I think you understand that this is a work of such a volume that you oftentimes don't have resources to do monitoring of social media on a day-to-day basis. So why is this important? Is because this allows us to see the creation of various narratives, of types false narratives, and to see how these narratives, when are they created, how are they created, how they are spread within the Azerbaijani public, and sometimes also, and also we try to see how this affects Armenian population and the public discussions in Armenia as well. So what I mean by this is that by monitoring Azerbaijani public discussions, we can see how they affect the speech of Armenian actors, both in Republic of Armenia and in Artsakh. We document our findings and try to present them to international actors, to representatives of foreign states, and as Anna already mentioned. And most recently, in September, we published a report on the consequences of Azerbaijani military attack on the Republic of Armenia, which also included a separate chapter on hate speech. First of all, I would like to mention that we believe that Azerbaijani policy of promoting hatred towards Armenians is one of the underlying causes of torture and inhuman treatment of ethnic Armenians, both back in 2020 as well as in September this year. It is important to mention, we do mention this from time to time, but it is important really to remember that there were documented cases where Azerbaijani servicemen, while torturing Armenian captives, were bars for bars repeating the words of Azerbaijani president. So the impact of this kind of hateful rhetoric is really immense on each and every person and on service persons as well. In September, it was important to also note the both the speech and the treatment of female service persons, because in this case we had a situation where they were targeted, the service persons were targeted not only based on their nationality, but also based on their gender. And this can be noticed by both sort of reviewing the ways, like the specificities of the violence towards them, the mutilation of their bodies, but also when reviewing the expressions of social media users in this regards, because the social media posts were filled with not just Armenophobic speech, but with sexist speech, with objectification and sexualization of women's bodies, with stereotyping of Armenian women and female gender roles, etc. So this is also an important thing to note when we talk especially about the attack of September 2022. I would like to mention that those narratives created by Azerbaijani public officials think and act. So with the election corridor, we saw this first with the Ministry of Defense regularly spreading with the Ministry of Defense of Azerbaijan, regularly spreading this information about not just the military forces of Republic of Armenia, but military units in Artsakh, attacking the Azerbaijani military positions, which then allowed many public figures and as well as experts to speak about this and push the narrative that Azerbaijan should really close Lychin corridor and cut off Artsakh from Armenia. And then you monitor the social media posts and you see regular users just repeating these statements when like 2 months ago, you wouldn't notice these kind of notions from them. So this happens over and over again, and it is important. That's why it is important to regularly monitor both the official statements as well as the posts of regular social media users. It should also be noted that when we're talking about the statements of public officials, they sort of create an image of an Armenian, which further helps them to dehumanize the population of Armenia and Artsakh, and be more effective in their that Armenians are presented as a cunning, two-faced, hypocritical, treacherous nation from which betrayal and malice are expected. Officials regularly characterize Armenian fascism, emphasizing the impossibility, highlighting the inevitability of the use of force by Azerbaijan. So this image is important for them then to have a justification for the continuous first of use of force and really use of force. Sometimes the statements of public officials are legitimized then by the president of Azerbaijan, or there is also a situation where first the president says something, like creates some narrative sort of, and then other public officials, these are often members of the parliament, repeat this in other ways and maybe popularize it in a way, make it more evident in Azerbaijani public discussions. I think these were the main things I wanted to mention, and I will probably stop here, and if you have any question, I will try.
Thank you, Herine, for your comments, and thank you for telling us about the official Armenophobia that's being propagated in Azerbaijan, and the question that I had about it, but we'll probably revisit how much of it is organic and how much is it consequences of Azerbaijani state propaganda. The cultural aspects are especially fascinating to me. But we'll revisit it, I'm sure, during our conversation. And right now, I would like to introduce our last speaker, Shakir Agosyan, who is the representative of the Republic of Armenia to the International Court of Justice. You may have seen and heard Yerisha's name with regards to the decision of the court. So he's not an unknown quantity for us. And I'm especially glad that he's joined us on this panel. Yerisha is also the representative of the European Court of Republic of Armenia's representative at the European Court of Human Rights, ECHR. Yerisha Agosyan has received his LLB and PhD from Yerevan State University, as well as an LLM from Georgetown University in Washington, and a master's from Stanford University. Thank you, Yerisha, for joining us, and we're looking forward to your contribution.
Thank you. Greetings to everyone. I think it's different time zones I never placed. And maybe good morning, good afternoon, and good evening, all in one place. Glad to see you all and so many familiar faces. And it's an honor to make comments and to make remarks on this important issues, and in the company of this outstanding speakers. Thank you very much, and thanks a lot for the contributions. And I'll try to structure my remarks based on the work that Armenia has been conducting so far in the past years. Interestingly enough, I think we may say with some confidence that for the past several years in the Armenian diplomacy and foreign policy, we have started using a new tool, or a new set of tools, which are the international legal tools or international courts, which Armenia has never been directly using, in the past since its independence. We have been indirectly involved in quasi-interstate cases, which have been presented by individuals, although they are or they were relating to the conflict per se. But after the war in 2020, after the 44-day war, Armenia actually initiated first ever interstate proceedings, first at the European Court of Human Rights against Azerbaijan and against Turkey later. And then in a year after, Armenia also initiated one of the main proceedings before the International Court of Justice against Azerbaijan again. And those are the main pending proceedings at this point in time. And of course, the thing is that since Armenia has not been very actively using international legal tools, we didn't have much of experience in using those tools. And which also means that we didn't have much understanding how those institutions operate also, and what impact those institutions can bring. That's also a new thing, because we are trying to observe that as we go. The other interesting and important point that I want to emphasize here is that the situations that those institutions are now facing are a bit of unique. For example, if we are if we put, for example, take the European Court of Human Rights. European Court of Human Rights is traditionally a more individual-oriented human rights court, while in this scenario of cases we're presenting to the court very complex set of facts which are relating to an active armed conflict, century old, very complicated conflict between two countries. And I know that this is not a new thing, because the court has been starting to face such cases, starting maybe with Georgia versus Russia, then Ukraine versus Russia, now Armenia versus Azerbaijan. And I think those series of cases have many things in common. And of course, the court's case law, we have been looking at the court's case law when we were putting together our applications, our interventions and requests, and trying to understand how the court will be reacting. Because as you also understand, international courts are very, let's say, sterile institutions, and they are very cautious institutions, to put it in a more politically correct way, because they are trying not to get too deeply involved in those controversies. The previous speakers presented important remarks relating to the conflict relating to Artsakh and Nagorno-Karabakh, and of course relating to the possible outcomes, whether that would be in the form of R2P, or application of the R2P doctrine, or trying to seek through the way of remedial cessation. I think all of them are highly valid points. And the last speaker also spoke about the racial rhetoric, racial discrimination. I think the root cause and the very essence of the conflict is lying within exactly that, because the atmosphere that we live in now today, and what we see in Azerbaijan today, is highly complex, very dense, institutionalized, state-sponsored racial discrimination, very firmly institutionalized. And I even would dare to say that this is even forming a very essence of the statehood in Azerbaijan. That's what I would say. And that's very sad to acknowledge this position, but that's true, because that's so ingrained with the public institutions and the public officials' rhetoric that it's really it will be very hard or difficult, not even maybe impossible to eliminate in a very short matter of time. And we of course have presented those evidentiary materials primarily to the International Court of Justice when presenting our application instituting proceedings, and also the request for indication of provision of measures. which led to the order of the court a year ago on 7 December 2021, and where the court actually acknowledged many important aspects of this racial discrimination and presenting it in summarizing it actually in three main pillars of provisional measures applied relating to persons under the authority of Azerbaijan of Armenian origin, the cultural property, and the termination of the racial propaganda, anti-Armenian propaganda by also public officials. But in any case, this is just a start, because the implementation of the provisional order is quite burdensome. I don't think that Azerbaijan has changed much since 2021 December. I think maybe the situation got different, worse, or it's the same, or no, it's just living its life. But and that also makes this case highly important, and it makes its case, underlines the importance of this case, the crucial nature of this case. Of course, we've seen some behavioral changes down the line when we were litigating, when we had the decision coming out and back in December 2021, which are maybe, to put it correctly, more artificial changes, or maybe intentional artificial changes to just give a sign to the international community that Azerbaijan is trying to abide with some rules of the civilized nations. So, but the essence still remains the same. So this is, and I think that this the case actually marks the core problematic of the whole conflict. I think what happens now today with the blockade of the corridor, not only the blockade of the corridor, the behavior of Azerbaijan, the treatment of POWs and captives in Azerbaijan, the war crimes that we witnessed in September, the execution or the summary execution of all the Komba Armenian soldiers, or the mutilation of a female sniper's body, all of them are not exclusive, but all of them, I think, are the result of this decades-long, very targeted racist anti-Armenian propaganda. Those are the results of the fruits of this propaganda. So this is how important the work in the direction of fighting this racist propaganda. And if you even look at the convention's preamble of the 1965 Convention on Elimination of All Forms of Racial Discrimination, the convention itself cites the importance of underlines the importance of the fighting against racial discrimination, and of course that's the aftermath of the Second War. But the preamble links the importance of the elimination of racial discrimination with the peace and with the security in international relations, which is true, because one of the primary causes of endangering or creating the necessity or need to use force, the aggressive force, is exactly this in this very particular scenario. And so I would emphasize this, and of course we are continuously presenting many evidentiary materials to the court. We have actually been working tirelessly in the past couple of days relating to the events that unfolded with regard to the blockage of Bachin corridor. We applied to the European Court of Human Rights, requesting provisional interim measures in this case, according to the language of this court. We received notification from the court just today that they have communicated our request to the Azerbaijani government, giving them until 19th of December to respond. So we'll be waiting for the response, and then court accordingly will decide based on that. And we also have sent an official letter through ICJ to the respondent country, requesting clarifications and raising our allegations and giving some time, 48 hours, for them to respond or to take action. Otherwise, we'll file a request for provisional measures at the court again. So we'll see what happens, because that's another tool that possibly can influence the course of action in the future in a matter of a couple of days. But I highly value and underscore the importance of the international legal institutions, international courts here, although some of you or many of you or a lot of people I know that they are highly skeptical with regard to those institutions because you don't see the immediate benefit of using those institutions, which is normal. You may not see those, but still it doesn't mean that you shouldn't or we shouldn't utilize those institutions, or you would try to enforce the orders and decisions that we have received throughout the procedure. One very small example that's maybe that can be very important to. It's a very small example, but when we received the order of the court back in 2021 December, the court's order, which presents it is actually based on the application and the pleadings by the Armenian legal team and the, of course, presentations and replies to those arguments by Azerbaijani side, which gives a lot of important legal qualifications and important assessments, which then have been taken by a number of international organizations and institutions and used in their language of the political statements, political documentation, which extended the impact of those decisions and the order, and which we saw also played some impact, some role on creating some, or at least creating some, let's put it in this way, problem for the Azerbaijani side to justify themselves, which is in reality, I think we are not naive. We understand how those institutions and what impact they may have, but that also emphasizes that we need to consistently continue pursuing this path. And of course, as I said, this is very extensive work. It requires a lot of evidentiary work, a lot of delicate evidentiary work, and which means that we're working in a team, by the way. A lot of partner organizations like Kasia mentioned, and what Sheila does, and what the Human Rights Ombudsman also officer are doing there. I think all of them are highly relevant and very important for us. So I think I'll stop here. I think this is enough of comments. Maybe it's better to wait for the questions then. It will be more easier to discuss then. Thank you.
Thank you, Erishe, for a graduate seminar on how international law works and how international legal mechanism works. Certainly a lot. I learned a lot in this brief section, and believe me, I am learning a lot today. Let's turn to some questions, and I have a big question. Armenians and justice, historical legal justice, have a weird relationship. Sometimes it feels like we're chasing a wind. Sometimes it feels like a beggar courting a princess in a castle, and is ever forlorn because the princess never returns the courter's love. And when I use the word court, that is a pun that is intended. And the question I have is this, and it's inspired somewhat by The Godfather, the movie Godfather, which I love and which I revisit occasionally. If you remember the very first Godfather, the opening scene is a father very much concerned with the well-being of his daughter, who had been taken advantage of, his words, another way of saying been raped by two of her peers. And in the opening scene, and I pulled down the script to read it just to show the similarity of the situation that oftentimes we Armenians find ourselves. There is this episode that really sort of gets under my skin every time I see it, and I always connect that predicament of that wronged father with the Armenian situation. And this is the line that I would like to read. "I went to the police," the father says, "like a good American. These two boys were brought to trial. The judge sentenced them to 3 years in prison. Suspended sentence, suspended sentence. They went free that very day. I stood in the courtroom like a fool, and those two bastards, they smiled at me. Then I said to my wife, for justice, we must go to Don Corleone. So it is sort of, for me at least, it sort of captures that ethos for the Armenians. Like I said, we chase after justice. Justice, runs away from us like wind. And so when you look at these issues, sometimes it feels like the wheels of justice grind. Sun Tzu said, the wheels of justice grind slowly, but they grind finely. But in the Armenian case, it increasingly feels like the wheels of justice just grind in place. They're not going anywhere. Certainly, they're not pulling us with them. And whatever they're grinding sometimes feel immaterial, untangible, just moral, and ephemeral. So I'm sitting here and I'm thinking, what, and this is also the question is primarily for the for Judge Abgarian. Who is this Don Corleone? Should we pursue this Don Corleone? Because the legal mechanisms seem to be so lacking in giving the Armenians this justice. And I'm saying this expressing, I guess, not just a personal feeling, but the feeling of a lot of people that we feels like we just sit in place. We don't receive the crumbs from the table. We believe in the law. We believe in the legal system. We believe in the international legal system. But it's not, it feels like it's not doing anything for us.
Okay, Artyom, I mean, you asked a judge this question. So, but let me put it to you this way. In your Godfather example, he actually went to the police and he went to trial. That's way ahead of where Armenia and Armenians have been, okay? So let me tell you, for 30 years, we've had an independent Armenia. For the first time, we've had a sovereignty, and a sovereignty that came into play, 600, 700 years after, King Levon, right? Back when justice, international courts, that's the systems, UN didn't exist, okay? So this is really, for the first time, Armenia has statehood. So for the past 30 years, we've been living under the protection of Don Corleone, and that's called Russia. Okay? Yerishe, you don't have to make any gestures. It's okay. We'll just... We haven't gone to court. We haven't even gone to the police. We've never used the judicial system or the justice system. With regards to the genocide, what have we done? The only famous case we have to our name is the Tehlirian case, which, by the way, it's a fabulous case. And every year in court on April 24, I would pull out the transcript of the Tehlirian trial, and I'd read it in court, and I'd read it to my colleagues when I was in a law firm, to say, this is an amazing case, one of a kind, where everybody said, yeah, this guy shot this guy, but we're going to let him go because he was so traumatized and it was justifiable murder. And then when you go forward, you realize this guy was never even traumatized because he never saw anything from the genocide. That's the best case we have of us going to court. That is abominable. However, is it our fault? No. We've been a Soviet republic up until 30 years ago. We didn't have that agency. We didn't have a police to go to. We didn't have a judicial system to go to. Now we do. And I want to take my hat off to Yerishe, not because I've gotten to know him personally, but the minute this country, our country, the sovereignty of Armenia, took the heroic step of going to court, because what do Armenians in Armenia say? which is different than what Armenians in the diaspora say, okay? There's a huge difference. Armenians in Armenia and on Artsakh constantly live in fear, okay? Let's not publish the pictures of the POWs, because what's going to happen to the ones that are still in captivity? Let's not talk about what they've done to us, because Azerbaijan might do worse. Let's not piss off Russia, because what else are they going to do? They've done it. They've bombed us, they've shelled us, they've blockaded us. How is that policy going, by the way, of placating the Russians? How's that blockade going for you guys? Not well. How is it that the treatment of the POWs are going? We still have over 120 POWs in captivity. Are they being released? No. So we've never used this amazing tool of going to the police. Going to the police means you file a report. If you're going to file a report, you have to tell the truth. If you're going to tell the truth, you're going to tell them what they've done to you. And Armenians in Armenia don't want to tell the truth. They want to hide the truth because they are in fear, and fear is what freezes you. So the fact that Armenia and Yerishe and his team have taken this heroic step of pushing forward, this is a first time for us ever. And the case of ICJ, Yerishe underplays this case. The Georgia versus Azerbaijan never got into court at the ICJ. The ICJ found that they had no jurisdiction and threw the case out. We have already gotten provisional decisions by the court, and it's new precedent. The ICJ, under the CERD that they brought this case under, has never established rules or made claims with regards to the treatment of anybody under the captivity of another sovereignty, specifically POWs. And yet they made provisional decisions. They've never made decisions with regards to cultural heritage, and yet they made these decisions. So Artyom, for the first time, we actually went to the police and said, hey, someone's done something for us. And please, let's not go back to Don Corleone, because there's a huge part of the Armenian society that still believes, we need that godfather. We've had that godfather. Godfather has mistreated us and has continued to mistreat us. Now, does it mean we get rid of him? No, we are in a political jam. We have to play both ends. But Godfather cannot stop us from using the judicial system and the justice system. I want to say something about justice. Armenians have romanticized the word justice. Oh, people need to hear our pain. That's not justice, my friend. That's just agony and grief. All right. Justice means you go to court and you fight. And the fight that is ahead of us is huge, and it is long, and it takes years, and it takes meticulous, detailed work of documenting facts, and then getting those facts. I'm going to give you a few examples of how difficult it is to collect facts in Armenia, okay? Right after the war, within 10 months of the war, the Center for Truth and Justice had substantial success in collecting testimonial evidence from POWs that had just come back, okay? Where they still had their injuries on their backs, they had the damage, the trauma, and we collected these testimonies with hard data and their firsthand stories. 2 years has gone by since then. Some of these POWs, by the way, we don't collect this testimony just by asking for it. They have to sign consent forms. We are very thorough. It's a 7-page consent form where they have to initial and sign. We don't do things unless they completely voluntarily are willing to do this. 2 years has gone by. Some of these POWs are contacting us and saying, I don't want you to use my testimony. I want my testimony back. Why? That's how they are. They revert back. They get scared. They want to push it under the rug. Armenians want to push it under the rug. They want to say, we no longer want to talk about this. Okay, what's happened has happened. Well, if you don't hold on to your evidence and you don't use it on a regular basis, you can't seek justice. So it's the first time we've actually sought justice, and we've gone really far, much further than I had hoped. There's a huge challenge ahead of us. Yerisha and his team have a lot of work. And here's my message to the Armenian people, both in the diaspora and in Armenia. Don't hold your breath, okay? Justice doesn't happen in 20 minutes. There's no swift justice. It takes a long time. We might lose. It doesn't mean that's the last resort. You go back, you try again, okay? There are so many avenues of creative ways of doing this, but the tribunals and the courts that we have to go to are very limited. They're super limited. I see questions about, you know, can we put the names of Azeri criminals on Interpol? Can we do this? Can we do that? These are super complicated questions. It's not as simple as let's just arrest someone and then take them to court. By the way, there are groups in Germany, in Argentina, that are doing this actively, but this is not information that needs to be discussed publicly. This is not the forum for it. There are amazing legal groups that have all come together and the work is happening. But I have to say to my lovely people, Armenians everywhere, take a deep breath. It takes a long time. So I don't know if that helped.
Oh, it helped a lot, and I see Sheila wants to answer, or she has a question or a comment. Sheila, can you unmute yourself?
Yeah, I have I need to clarify two things. The Tehlirian trial was not the only instance of justice. There were the Malta trials, and a lot of Turkish war criminals were prosecuted by the British government, even though they were eventually, amnestied. But we have a record of that. So we do have more justice than we think. And I think we often forget a lot of good things that have happened. The second thing I wanted to clarify was Georgia versus Russia actually did have provisional measures and was tossed out on jurisdiction after. So let's not put the cart before the horse and think that we actually won anything just yet. We won a big thing. That's a first stage, but there's still another hurdle that needs to be overcome. And that's not to diminish at all. I completely agree with you that the steps that we've taken are unprecedented, that Yenisha has taken are unprecedented, and how important that they are. But, I think justice has a very subjective element to it as well, that you can go to the police and you can ask the judge for justice. I've just seen, honestly, I think justice, the way we perceive it, is almost a luxury. So many people go without it and find the peace in their hearts. So I do agree also with Judge Abkarian in terms of like the sob story needs to stop and the emotional part needs to stop. And we need to take agency on ourselves of overcoming this victimization and becoming strong with or without justice. It's not necessarily going to come. You take the steps, but justice comes when you actually have a better life and, somehow survive the impossible. So that was what I wanted to say it a little more eloquently, but I don't want to, I want to let other people also have their say.
I see Yerisha Giragosyan has his hand. You wanted to comment or add something?
Very briefly, because I see Van Zan's hand is up too, so I just won't take much time. In reality, I think we have just started this long road. I agree with my co-speakers. It is just a start, and I think we haven't even reached the end of the beginning. I mean, there are many stages ahead of us, and it is very meticulous work that we need to be ready. And I think we missed some time since the independence, but it's okay. And I agree with Judge Abkarian that it is okay because we have been a Soviet Republic. We just got independence 30 years ago. We inherited the educational and the value set. And then we are now just moving ahead. We are now just trying to use the institutions as a sovereign state, which is the first big step. That will take somewhere. It requires long and very hard work. But I see that a lot of possibilities. But if you use those tools with the correct strategy in mind, and also with some patience, and also with coupling with some other tools, because those tools should not be used only the judicial tools, only legal tools, but also the diplomacy and the political tools too, because they support one another. And the other point that I wanted just to make, the difference between the courts per se, like as perceived and like on the national legal level and international legal level, were like completely different stories. Those also you should bear in mind too, because the international courts have a specific operation on the international level, and I just described it in my very brief introduction. We know that, and that's why it doubles down the work, as opposed to the courts. For example, if you go to the court on a national level, that's just a completely different story. So here you have the front of work, or the front of war, is much wider. I would put it in this way. Yeah, I'll stop here. Thank you.
Thank you, Resha, for your comments. The other question I had, and it's inspired partly by Judge Abgaryan's comments from this panel and from panels past regarding the evidence gathering culture in the Armenian judicial system. Thankfully, I haven't been through the Armenian judicial system. I haven't been through any judicial system except the immigration judge who I didn't get to see, who approved my immigration to the United States. So when it comes to Armenia's international legal engagements, and we see, I mean, there is a lot of good work being done by the likes of you, Yerishe, and much work remains to be done. So the question I have, the thing that interests me, are there any reform works in the Armenian judicial system to sort of upgrade even such elemental stuff as evidence gathering and presenting it in European and Western courts and so on and so forth? Are there any efforts done on government level? Maybe the human rights defender also can chime in and comment. Because to have a strong case, you have strong evidence. You have to have strong evidence. It's, I mean, the logic of it is quite simple. And in the Western court cases, I mean, look, a lot of it comes down to your legal narrative. And
yeah. Should I start?
No, go ahead. Yeah.
Very briefly, it is a complex task. Of course, there are efforts being made. A lot of reforms are tackling exactly that particular issue. Like, I think all of the legal judicial reforms that Armenia had in the past have had this agenda item among many other things. But I think the problematic is linked again to the legal culture that we inherited. Because what we inherited from the Soviet time, we inherited the legal system with a strong prosecutorial powers and with very limited judicial powers and very limited role of the attorneys in the court. Then we started to create, based on that heritage, we created our own judicial system. We tried to replicate with the Western best practices judicial system, independent courts, independent attorneys, and then trying to a little bit tone down the prosecutorial system. It works to some extent, but of course this heritage remains, because that also continues with the legal education that we have in place. And I think to reach the complete exercise, or to complete this exercise fully, you need to also reform the legal education in the first place. Because what you teach at law school, for example, that also has had an impact on how judges think and how prosecutors think, or how investigators operate, and everyone, how attorney behaves in the court, and also this value set. And this is I have been thinking about it for the past couple of years, and I think this is very. It is happening now in Armenia. It's been slow, of course. I'm sure that the quality of the evidentiary materials that are being collected, for example, by the investigators, now are like much better than compared to like years ago or 10 years ago. But still, there is a room to work, to work and improve. So I think first is just continue. One of the core issues and to have a long-term impact, you need to tackle the education system. That's my take on that. Thank you.
Thank you. Anyone else wants to chime in on maybe Karapetyan? No. Okay. Let's open the floor to some questions from our audience. I see Vahan Zanoyan has raised his hand. I don't want this to become sort of a video conversation when everybody jumps in, but I'll make an exception for Vahan. And if you could submit your questions to the panelists through the chat, I can then read, because I don't know everyone. I know Vahan's work, so I trust that his question will be significant and juicy, and I don't want any trolls, for instance, that have joined us to jump in and mess up the wall. I'll unmute Vahan. Okay.
Oh, I'm sorry. I don't intend to have any special treatment here. So if this is not the form, I will refrain from asking my question if this is not the form that you have. But I didn't realize I had the option to raise my hand, so I raised my hand.
Okay. You're here, so ask your question.
I'm sorry. My question is very simple. First of all, I'm very, very impressed with this panel, and I know the panel has focused on current legal issues. We're trying to manage the present, which we usually do. We have a crisis in Lachin corridor. We're trying to manage the various atrocities of Azerbaijan. But I have a much more fundamental question. I would like to go back to the root cause of all this. And that is, why haven't we challenged the legality of Artsakh being part of territorial integrity of Azerbaijan? Because the legal basis, again, I'm not a lawyer, Yerijan, forgive me for getting into your territory here. And I'm sorry Gassia left. And Ms. Palian, I hope you can chime in on this. But as legal experts, I go back to the history of how come Artsakh or Nagorno-Karabakh became part of Azerbaijan's territorial integrity. Go back to the events of 1921 and then to the referendum. We have a lot of legal basis to challenge this perception or this acceptance by the international community that this is part of Azerbaijan. First question, which is not very relevant, why haven't we done it? Second question, which to me is much more relevant, can we do it from now on, moving forward? I'd like to hear a legal opinion on this.
Thank you, Vahan. Anyone wants to tackle this big question? A question of an original sin?
I think it's Yahisha's question. Nobody else can answer that.
But Artyom, you put it very well. It's the original sin. We would have avoided all this if we had tackled this properly from.
So should I start?
Yeah. Yeah.
All right. But I think Sheila should compliment too, because her topic of the RTP and also the remedial secession part relates to the questions to maybe the later phase. But why we haven't raised this question? It's we didn't have that much of long time to raise this question, but I think there are several reasons why we haven't done it so. Maybe to start with the notion of this, and this, I think it has been discussed very extensively, the tension between the two principles, the territorial integrity and the self-determination principles, which has been on the table and discussed and in a distorted manner, I would say, for I think for the period when the Minsk co-chairmanship has been in existence. But in reality, the territorial integrity principle, it is a principle which regulates relations between two countries. It's an interstate relations principle devoted to the regulation of the interstate relations. This has been actually emphasized by the court, by the ICJ in its opinion in 2010 on the Kosovo case, where the court actually very indirectly commented on this matter, saying that the principle actually does not create any obligation for non-state actors. And here the court tried to somehow resolve this tension, the artificial tension created between the territorial integrity and the self-determination. That's the first step. The second step is that which is important as a premise for you to understand why the court is saying so. That's very simple, because the notion of territorial integrity is enshrined in Article 2.4 of the UN Charter, which relates to the prohibition of use of force. The prohibition of use of force by member states against the territorial integrity and political independence of one another. So that creates this legal basics for that. When we were speaking about the self-determination problematic, it has some historical development to it. The self-determination principle has primarily been coined with regard to the context of the colonial or the colonization. Mostly that has been the context of the principle applies, starting from the beginning of the 20th century, then more actively, I think, after the establishment of the UN. And you had this principle being applied, and most of the documents which have been adopted to enshrine the principle, to set the principle, most of them have been focusing, narrowing down the application of the principle to the cases of the when the colonial states were seceding from the when the colonies were seceding from the metropolitan states. So, but later on, like when the legal doctrine and the international law evolved, and due to this massive change, massive development of the relations and the shift of the context, I think the new notion has started to be developing, which came, I think, to start being coined maybe later with cases like maybe starting with Bangladesh, I would say, then going to coming to new cases where the Kosovo is one of the examples, and where international legal doctrine started to speak about the secession or remedial, the idea of remedial secession. When you look at the legal positions of different countries presented to the International Court of Justice in the framework of the ICJ proceedings in the Kosovo advisory opinion case, you find the use of this concept by many member states, including the United Kingdom, for example, when in its legal opinion, the UK uses the term remedial self-determination. Similarly, Russia did the same, using the same concept, using the allowing the possibility for a unit or people to secede when a massive human rights violations or is happening, or the people is oppressed, highly oppressed. And you have a similar position by, I think, Germany, and if I'm not mistaken, Netherlands and some other countries who presented the legal positions to the court. I think even those, I think France too, some of the permanent member countries, they allowed this possibility of this legal doctrine being applied. And then you had a lot of legal academic literature discussing this concept, remedial secession. Then it has been criticized, of course. So why we haven't been using it? It's a good question. Maybe we didn't. I don't know why. It's really hard for me to answer, because you maybe have to ask the right people, maybe in charge at that time, because we have been using the concept wide enough self-determination, which is quite wide, which implies from the internal self-determination to external self-determination, meaning you can be allowed to some status in the framework of territorial integrity of Azerbaijan, and to the extreme to allow to secede from Azerbaijan when you prove that there is no other way than to secede. And today's international law, I think it's to me it gives that opportunity, but the problematic is that you don't have a very precise legal text, I mean treaty text, precisely enshrining this procedure and this this doctrine, how it should be implemented. So it makes the case harder. But if I would put it maybe in a way that this international law can in no way be interpreted, or the territorial integrity, you cannot interpret territorial integrity to allow the violations of, or systematic violations of oppression of a people, of a group of people. And here, I think in this case, we exactly have, I think it's a similar situation. I think as Sheila presented in her presentation, it is highly, and also the case of the International Court of Justice is exactly speaking about that. And when we are speaking about the institutionalized racial discrimination, ethnic racial discrimination, that exactly is presenting the problematic there, because you cannot have, how would one imagine having ethnically Armenian populated territory inside Azerbaijan? I don't know. It's really, I cannot imagine that, because it's impossible. It will lead to ethnic cleansing, definitely, or genocide. So this area of international law, because of being a little bit loosely, I think, enshrined, allows for ample room for manipulations and highly politicizing, I would say so. So, but still, I think there is a room for us to work. I would say that there is a possibility. So to answer to your question, to last question, whether we can do it now or whether there is a possibility, I would say yes. Maybe better to stop here. We can discuss it later with you.
Thank you, Yerishe, for your comments. We have time for one or two more questions. We're about to hit the 2-hour mark. So the question is for Sheila Paylan. It comes from Maria Gevorkian. The question is this: in your opinion, what urgent action needs to be taken to openly and actively seek the assistance of the international community in preventing this international crime? I'm assuming Azerbaijan's attack against Armenia. It's not defined here. And moreover, seeking an institution of proceeding before the ICC at the initiative of the UN Security Council against the military and political leadership of Azerbaijan. Big question.
No, it's not that big. It's pretty easy, I think. Armenia needs to ratify the Rome Statute now, yesterday, 2 years ago, and then needs to step up its lobbying efforts in the hallways of different UN organs to get resolutions passed or get sanctions going. Sanctions are almost impossible because, well, maybe not. I don't like to say that, but the Human Rights Council, for example, is where a lot of these international or investigative mechanisms, these accountability mechanisms, commissions of inquiry, fact-finding missions, they're coming more and more out of the Human Rights Council, and there you don't have a veto problem. Armenia's been on the Human Rights Council for a couple of years now, and it's about to end its tenure at the end of this year, and hasn't actually, as far as I can tell, done anything to move that needle forward. So, you know, the UN is a club of all the states in the world. It's not somewhere where you or I, or, you know, we don't just rock up there and say, hey, you guys need to do this. It's really up to the leaders of the world to come together. And so the leader of a country that has an interest in moving something like that forward should be, or, you know, those diplomats that are representing Armenia there should be moving these things, pushing these things forward. So I would say that the biggest deterrent to future crimes is punishing past ones, or at least having some mechanism in place that says, hey, we're watching you, and this can lead to real criminal prosecution somewhere down the line, not just, you know, like real criminal prosecution. People can go to jail. And for that to happen, we're going to need, for political lobbying to get those permanent representatives to push forward, like, you know, go from office to office and show the resolution and say, are you with me? Are you with me? That's the only way. I hope that answers the question.
Thank you. And just to give people context, and I constantly remind myself about, you know, I made the remark about the wheels of justice sometimes grinding in place. A bit of a context, if you remember, in 2014, the Russian rebels shot down a plane over Ukraine. The circumstances, I mean, the evidence was not just circumstantial, it was meticulously put together, but it took 8 years for a crime of that magnitude just to be brought to the courts and a court decision to be made. So it takes quite a while for these issues to be addressed and redressed, I guess, judicially. I think we'll conclude with one last question. It's addressed for Yerisha Kiragosyan, but I will also take the liberty and ask for comments from Anna Karapetyan and Herine regarding the Armenian POWs, because you are in the the state bureaucratic system. You may have more information on this. Do you have a figure of confirmed Armenian POWs held in Azerbaijan, and what work is being done by the Republic of Armenia and European international courts for their release? I think it's a very important question, and it keeps me up at nights sometimes when I think about the POWs. Thank you. I guess.
Yes.
Anna, do you want to?
Start.
Yes,
Anna.
I will continue after Mr. Kiragosyan's presentation.
Please start, Anna.
Thank you, Mr. Kiragosyan. So as of now, we do know that there have been 33 prisoners of war being kept in Azerbaijan still. And here I would like to mention about the important work that has been done by the Human Rights Defender Office with regards to the gathering information about the torture of POWs by the Azerbaijani authorities. So we have a non-public report that has been already on the table, and we have interviews, and we had interviews with 17 POWs returned from captivity. And the methodology of the conducting interviews with repatriated POWs shows the different stages of being tortured by the Azerbaijani authorities. I mean, in different stages, being in captivity, starting from the taking point, and then afterwards, in this center of the villages, they have been tortured and they have been beaten by the ordinary villagers, civilians. We have captured and gathered this information through the interviews with POWs. And you know that during the September attacks, of more than 17 POWs have been captured, and then afterwards they were returned to Armenia on October 4th. And the Human Rights Defender Office had the opportunity to provide to ensure private interviews with the repatriated POWs, and it clearly shows that the really torture, degrading treatment was orchestrated by the Azerbaijani authorities during each and every stage. And POWs also mentioned that the penitentiary service is like a heaven for them, because they have been beaten in each and every stage before being brought to the penitentiary institution. And this report is not available publicly, and we will distribute it among our colleagues, international lecturers, and we already sent it to the relevant international lecturers, and I will be happy to also share with you this public report, non-public report, and I will definitely ask you to also not share the report with any other actor, and also including the investigative bodies of Armenia and any other actor that could further double victimize the POWs, also considering the very sensitive issue in Armenia. Mr. Kyriakosyan, we will share also the report with you. It is on our table. If Mrs. Grigoryan didn't share it with you, so I will do it afterwards. And I will also share with the team, and we'll be happy to answer each and every question with regards to the torturing of POWs. And this is the important tool to use in international tribunals to show the real pattern of torture, inhuman and degrading treatment of POWs, because there have been zero cases where Armenians were treated like normal people. So it's a common problem, and it's a problem when we see that the way of being tortured is like the same. And that's why it should be clear that it's not only the inhuman behavior of one soldier, of one serviceman, of Azerbaijani government, or any other law enforcement official. So it's like being orchestrated, and it has an institutional character. And that's the important point that should be further brought to the attention of international lecturers. And I will be happy to also share this with you, and we'll think about further actions that should be taken from our side, from the side of government, from the side of Human Rights Defender Office, and from your side to further ensure justice for all these POWs returned. And Mr. Kyriakosyan maybe could further comment on the relevant actions that are being done by the Office of the Representative on International Legal Matters. So thank you very much.
Yerisha, if you have anything to add, feel free to add, but I would like to say that we should exercise mercy on our panelists from Yerevan. It's getting rather late. They have families, they have responsibilities, and they're not robots, and they need sleep. And I'm saying this as someone who's been sleep deprived in the last couple of years. Good sleep is very important. So, Mr. Kyriakosyan, if you have anything to add.
No, I think everything has been covered. We indeed have 33 confirmed POWs, not only POWs but also civilians among them. But there are, of course, cases of enforced disappearances where we do have some evidentiary materials confirming the presence of the person under the authority of Azerbaijani agents, but Azerbaijan rejects that they are in Azerbaijan. Those are around 26 cases at least. There have been more cases, of course, of missing persons who we don't know where they are, and their remains haven't been found, and because the DNA identification tests are being conducted when the remains are found. So like around 200, including those 26 enforced disappearance cases, just remain unknown. So this is only from 44-day war. And those 26 cases are those mostly where we have, for example, videos showing a group of soldiers or POWs under the Azerbaijani agents authorities, so soldiers control. And we have submitted actually those reports, not only us, but also practicing private attorneys. They have also been working tirelessly. They have been submitting it to the European Court of Human Rights, but unfortunately we haven't received any. We actually have received rejections on those cases. That's very unfortunate. So the European Court's toolkit is a bit limited in dealing with this kind of very complicated cases, these enforced disappearances or disappearance cases, unfortunately, but that's the case. Yeah, I think this is only part that I just wanted to emphasize. And yes, of course, we're actively using the evidentiary materials prepared by the Human Rights Defenders Office, by the way, and great thanks to them. That's a great work that they're doing. And all the judicial proceedings who are using their work, the reports of the Human Rights Defender, because they're a valuable evidentiary material. This is all. Thank you.
Well, thank you everyone for agreeing to put yourselves through 2 hours of questioning and commenting. Thank you for joining us. Thank you for your insights, and thank you for all your work. I know you occasionally get thanked for your work, but I would not miss the chance to personally thank you for all your work, all your hard work, and hopefully we'll all see and enjoy the fruits of your labors sometime soon. May the wheels of justice grind quicker this time around. Thank you, everyone.
Yeah, can I just jump in with very short closing remarks? It's actually, I can't believe 2 hours kind of flew. It's been very interesting, very super informative and insightful. And thank you, Artem, so much for great moderation. And let me just thank all of the speakers for making the time and trusting us and joining the panel. I think it's been amazing. And the fact that it's more than 2 hours just proves it. Thank you so much. And yeah, stay tuned for more events from AI, and see you at some point in the future. Thank you so much. Good night for the Yerevan people.